And so I'll just briefly highlight that Mr. Ward has a charge of being a minor in possession of alcohol in violation of section 574 of the Boulder Revised Code. And then there is an offer in the file, and I don't know, Ms. Wolf, if you're familiar with the court's process with respect to the deferred prosecution offers that are made. And I was going to do the entire group advisement first, but I thought since counsel was here, I can just share this with you, and then you can talk to your client if you choose to about this one. There's a standard offer that our prosecutors make in every MIP case. It involves a deferred prosecution for 6 months. This has been made available to Mr. Ward. It would require that he participate in an evaluation, and it's basically completing an audit. He may have already done that. And then our probation officer would determine a level of education that he would have to complete. If he completed the level of education required, then the case could be dismissed and the record sealed. And though technically it's for a 6-month deferred prosecution, our process is once we have that class in the file that shows the person's completed, if there aren't any violations in that short interim, then the case can be dismissed and the record sealed without having to go through the full 6 months. And then there is a $100 fee associated with that deferred prosecution. So I just wanted to highlight all that for you. Not sure where status you are as far as the case. If you need time, want to reset it, we can certainly do that. If you want to move forward with the resolution today, that's the offer that's been made.
If we could do one reset so that I could discuss it further with Mr. Ward. I think that's probably the direction we'll be going, but I just want to discuss it with Mr. Ward.
That makes sense to me. So what we're going to do there is just send you out to the counter. We'll reset probably 2 to 3 weeks out, assuming we have slots available. We'll set it for a dispo and trial setting date. Won't take any plea today. And this won't require a plea with a deferred prosecution. And then if we can have someone print out the deferred prosecution or email it to counsel just so she has that document to review with client.
I would do it right now, Your Honor.
Okay. That's Ms. Bittencourt from our probation office. So we'll send you out front and you're going to email that. Is that correct, Ms. Bittencourt?
That is correct.
All right. And assuming we already have your email address in our system, we may already. So Ms. Wolf, you'll get that by email. We're going to send you out front. Clerk's going to get you all a new court date. I'm going to authorize Zoom. In person's my preference, but since the defendant's already been here once, we could do Zoom. It's a little more complicated because he will have to meet with probation. So it makes more sense for him to be here for that next court date. If it were going to be a date where you're going to still reschedule some more, or you're going to plead not guilty and set for trial, then it would make sense to just do it by Zoom and we could do the trial setting. But if he's going to accept the disposition, he should probably be here so he can meet with probation and go over all of the responsibilities. It's a fairly straightforward process, but it goes much more smoothly if the person's here with our probation officer.
Thank you.
All right, you're welcome. So, Ms. Wolf, I'll send you out front with Mr. Ward, get you that new court date.
Perfect. Have a great afternoon.
All right, you do the same.
Good afternoon, Your Honor.
Good afternoon, Mr. Janes.
How you doing?
I'm fine. How are you?
Great, thank you for asking.
All right, good. Sure, I've got the right docket pulled up here. And Mr. Janes, there are actually 2 cases that are pending for you.
Yes, sir.
Case number 2025-4997 and 2025-4869. Let me take a quick look and see which one has the offer in it.
699.
Yep, I'm pulling that up now. So there is, first of all, there's a motion to amend that was filed. It looks like when the officer issued the citation, there may have been a misspelling and added an N in your last name on that second citation that was issued to you. Or perhaps, no, actually it was the first one that was issued to you. So they've asked me to amend the summons to just reflect the correct spelling of Davenport without an N before the letter V, and I'm going to grant that request. That's a fairly minor request, and it's permissible under municipal code ordinances. Nonetheless, in that case number 2025-4869, there is an offer from the prosecutor that would handle both of the cases that you have pending. They've offered what's called a deferred judgment. A deferred judgment means that you would be expected to plead guilty to the charge, and in this case, to the charge of possession of alcohol by someone under the age of 21. And so it would be for a 9-month term. So if you were to plead guilty to that charge, you would be placed on the deferred judgment for 9 months. You would be expected to complete 12 hours of community service. You'd also be expected to have a substance use screen and follow through with whatever educational requirement our probation officer selected for you. And then you have to go through the next 9 months without any other similar charges that result in conviction. If you satisfied all of those conditions, at the end of the 9-month term, your guilty plea would be withdrawn, your case would be dismissed, and we would seal your record automatically for this case, number 4869. So that's an option that's available to you in that case. They've also indicated that if you accept that offer, that they would be dismissing the charge in the other case, case number 2025-4997. So even though you got two cases that are pending, one of them would be dismissed outright if you enter the deferred judgment on the other case. So that's how it would work if you wanted to resolve your case today with that plea offer.
Yeah, I think I'll be taking the plea
You want to
offer.
accept that? Okay, so that means you'd be pleading guilty to this charge of being a minor in possession of alcohol.
Yes, Your Honor, I understand.
And when I accept a guilty plea, I have to make sure that it's a voluntary decision. So I'm going to ask you a number of questions associated with that I'm required to ask of any defendant who pleads guilty to a charge. Are you pleading guilty voluntarily today?
Yes, Your Honor.
Is anybody forcing you to plead guilty?
No, Your Honor.
Are you under the influence of any medications or drugs or alcohol?
No, Your Honor.
Do you understand this charge of being a minor in possession of alcohol?
Yes, Your Honor.
Do you agree that there's evidence to support that charge?
Yes, Your Honor.
Now, you're doing this without the benefit of a lawyer to represent you. I could continue your case over if you'd like to hire counsel or if you wanted to apply for the public defender. Do you understand that?
Yes, Your Honor.
You're not required to do that, but I have to make sure that you're comfortable that you are not going forward with having a counsel to represent you. Are you comfortable without a lawyer?
Yes, Your Honor.
And do you understand that a lawyer might do a better job of representing you than you do representing yourself?
Yes, Your Honor.
And you're a CU student, is that accurate?
Yes, Your
So you understand the rights that you're giving up today?
Yes, yes.
I am going to find that it's a free and voluntary decision to plead guilty to this charge of being a minor in possession of alcohol. This allegedly occurred on August 30th of 2025 at 12th and College. How do you plead to that charge?
Guilty, Your Honor.
I'll accept that guilty plea. We'll place you on the deferred judgment. All right, so I have looked at the notes on the case. The deferred judgment offer is being approved.
Thank you, Your Honor.
You're welcome. I don't stand in the way of a deal that the prosecutor has made for people. I do like to know what the circumstances were, so if there's something that I need to address with somebody. But they've made the offer and I'm going to approve it. You'll have 12 hours of community service to complete. You'll also have the substance use screen that will be conducted by our probation officer here today. She will order a class. Because you're at CU, the community service is going to be supervised by the folks at CU. There's an agency called SLICE. It used to be the Volunteer Resource Center, but that agency on campus will provide you with opportunities on where you can do the community service. You're going to get a completion form from them. You're going to want to make sure that you email that to our probation department so that they have that. You'll also be required to complete whatever class is directed. All of you are likely to hear from the University of Colorado's folks, and that has to do with your obligation to comply with rules and laws in connection with being a CU student. So the Office of Judicial Conduct may contact you to discuss this very case with you as it pertains to your responsibilities as a CU student. So don't be surprised when you hear from them. The important thing to remember is that when you complete obligations for us, giving us proof that you've completed those, they may order similar obligations. They may want you to do an alcohol class. If they suggest a class that's a higher level class than we offer for you, take the higher level class. We'll accept that, and vice versa. If we order a class that's higher than what they want you to take the higher level class and give proof to both agencies so that they have what they need, and then they can close up their part of the proceeding, which is that Office of Judicial Conduct sanction that they may be imposing. So just want you to be aware that that's how the process might work. It will be the case for probably all of you that if you're a CU student, you'll be hearing from them because the University of Colorado Police Department and the Boulder Police Department send notices of the violations to the Office of Judicial Conduct. They share that information. So just want you all to be aware of that. They're usually a little bit behind us because we try to get these cases seen quickly, and they may not have quite the staffing to have everybody get an email or a text message, but don't be surprised when you receive that. Okay, there's a total of $165 in fees that you'll pay our court associated with this deferred judgment. When you go to SLICE, they're going to charge you a $25 fee. That's to supervise the community service. So we reduced our fees to make it a total of $165 instead of $190, knowing that you'd have that $25 fee with them.
Thank you, Your Honor.
All right, any questions for me?
No, Your Honor.
The one thing I will point out for all of you, and I'll probably repeat this a few times, is we're still pretty early in the semester. There will be another round of defendants who will be seeing me in the next week or two, or the other judge, Judge Hill. They're going to be ordered to classes. They're going to be ordered to complete community service, some of them. Make sure you get a quick start on these things. Don't put yourself in a position where you try to schedule yourself for the class and it's already full, or the only class that's available is one that's on a finals day or a midterm. You don't want to be in that position where you're having to select a class to meet a deadline. And if you wait, that could be the obligation that you face. So I would encourage you all to get started right away if you decide to accept an offer and get yourself signed up for the class and your community service, and get it out of the way before the press of work at school starts to become kind of onerous. You're still early enough on that you could get that community service knocked out before you start facing midterms. Okay. The other thing I will say for this entire group is the prosecutors here at our court are pretty lenient as the way they approach these cases. We don't want you to get the wrong message from the court or from the prosecution, which is not a big deal. Cases can be dismissed. You just go to a class and away it goes. That's the case when it's your first offense. And in fact, Mr. James, this is your second. You got two. They still wrap them up in one disposition for you. If you come back, you can anticipate that not only would you lose the benefit of the deferred judgment and end up with a conviction on your record for this charge, but you would have to face the other charge, which is not likely to be a deferral. It could be a straight conviction. I do not want you all leaving the university with as graduates, but also with a conviction on your record. And I certainly don't want you leaving with an alcohol or substance use problem. So I want you to take seriously these issues. There may be social reasons why you chose to drink, and it may not be anything other than just trying to socialize with your friends and not making good decisions. But if there is an alcohol issue or a substance issue that's causing you to want to drink to avoid facing problems, that's a whole different issue. And it's not something we're likely to cover in this first court date with you. If you've got that going on, talk to your family about it, get some help if that's the issue. I would suspect most of you don't have that issue going on, but there are often people who do. And so I want to share with you, make sure that you're addressing those issues in an appropriate way so that you don't end up with a problem going forward. I'm still in great communication with my very good friend from my freshman dorm, and he dropped out after about 2 months. And he had an alcohol problem and it has never gone away. And he's 60 years old and he's still working hard work and dealing with his alcohol issue. And it happens. And so I don't want people who are first out of their lives away from their parents, engaging in behavior that causes them to have a big problem. So be thoughtful about what you're doing. And certainly you don't want to appear back in court. So make good decisions as you go forward. But the good news is for you, Mr. Davenport, is you're both the older case, the one that we're dismissing outright today, 4997, that'll be dismissed today. And that record's going to be sealed automatically. And there's a conditional motion to dismiss, Nick, so I'll process that later on when I leave here, so there won't be anything for you to do on that other case. Okay, next step for you is meet with probation. You're gonna take 2 rights and a left down to the hallway there. Looks like Jose may walk you that direction. So they'll go over all this with you, get your signature on the documents, and then give you deadlines. Make sure you meet those deadlines.
Thank you, Ron.
All right, you're welcome.
All right, let's talk about that. This hearing in Judge Jeff Cahn's courtroom was a solid example of how municipal courts handle underage possession of alcohol charges, and it showed us 2 slightly different paths defendants can take. First up, Mr. Ward, represented by counsel, was offered a deferred prosecution, basically a 6-month probation light deal with an evaluation, some education, and a $100 fee. Judge Cahn patiently walked through the mechanics. Finish the class, stay out of trouble, and the case can be dismissed and sealed without dragging on for the full term. Mr. Ward's attorney wisely asked for a short reset to review the offer, which the judge accommodated without fuss. You could tell Judge Cahn values efficiency, but doesn't mind giving defendants and counsel the space they need to make a clear decision. Then we had Mr. James Davenport, who faced not 1 but 2 pending cases. Here, the prosecutor extended a deferred judgment covering both charges. This was a little tougher. He had to plead guilty up front, complete 9 months of community service, a substance use screening, and whatever class probation assigns, all while staying out of trouble. If he made it through, 1 case would be dismissed outright, the guilty plea in the other would be withdrawn, and both records sealed. It's a heavier lift, but a pretty generous deal considering it wiped out 2 cases in 1 stroke. Mr. Davenport accepted without a lawyer, and Judge Cahn carefully through the rights he was waiving, making sure the decision was voluntary and informed. That's where Judge Cahn really stood out. His style is steady, instructional, and at times almost professorial. He doesn't just process pleas. He takes time to explain why these opportunities matter, urging students not to delay community service and classes, and warning that leniency is for first-time mistakes, not repeat visits. His anecdote about a college friend who struggled with alcohol for decades added a very human note. It wasn't preachy, just a gentle reminder that small choices at 19 can echo much later in life. The atmosphere overall was calm, almost like a classroom more than a courtroom. The probation officer, the clerk, and even the university connection through CU's community service program all worked together smoothly. No grandstanding attorneys, no heated exchanges, just a judge guiding young defendants toward a second chance while making sure they understand the strings attached. If anything stood out, it was Judge Cahn's mix of firmness and patience. He wasn't indulgent, but he was clear that the system is set up to give students a path forward without permanent scars, so long as they take it seriously. Well, that's a wrap on this one. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.